Hello, everyone. We're in presenter mode, so I can check here to see as participants enter the room. We'll give everybody a few minutes to enter the webinar and get settled, and then we'll get started. It looks like the room's starting to fill up, and I want to be respectful of everybody's time. So I'd like you to welcome you today to this Lunch and Learn CLE event. I'm Philip Burris. I'm the chair of the Equine Law section, and I'm thrilled that you can join us today for a talk on Equine Law 101. Before we get started, I do have a few announcements. Our next CLE event will be April the 6th, and it will be on estate planning, and in particular, animal trust under the state laws of Georgia. So look for an invite for that fairly soon. We're also hoping, fingers crossed, to have an outdoor in-person social event the last week of April, either Tuesday, Wednesday, or Thursday of that week. So save the date for that and look for an invite if we can nail down things with the venue, which will be fantastic if it works out. So look for that. CLE credit for today has been approved. So the state bar will take care of that once it's completed. And we are in presentation mode today, as you can see. You can see me, but I can't see you. So if you have questions, please use the chat feature, and you can either enter questions and direct them to our speaker or me, and we'll answer them at the end of the event. So with that, I'd like to introduce our speaker, Lisa Boswell of Wellington, Florida. She is an attorney that practices in equine law, landlord-tenant law, contracts, and civil litigation. She speaks nationally on equine law matters and is also a published author on equine law issues, and we're very, very lucky to have her here today. She's licensed to practice in Florida, Colorado, Montana, and Wyoming, a broad swath of states, and is a graduate of the Nova Southeastern University Shepherd Broad Law Center. And I can't thank you enough for being here today, Lisa. And with that, I'll turn it over to you.
Thank you, and good afternoon, Phil, and thank you, members of the Georgia Bar's Equine Law section. It's my pleasure to be here and talk to you about one of my favorite topics, and that's horses. So as Mr. Burris stated, my practice focuses primarily on equine law related matters. And I get asked a lot of the time, what is equine law? And it's really an area, it encompasses everything from contracts to litigation. And it's basically any matter that involves a horse in some regard. I do quite a bit of civil litigation, disputes regarding boarding agreements, purchases of horses, fraud in the sale and purchase of horses, and also draft barn lease agreements, which is actually a big business in my neck of the woods here in Wellington, Florida. Right now, we have what's called the Winter Equestrian Festival taking place right here in Wellington, Florida, about half a mile as the crow flies out my window here. And it's a large horse show. It draws participants from literally around the world. We have Olympic riders and their horses here. So we are the center of the universe in the equestrian world right now in the winter here in Wellington, Florida. So it does give rise to a lot of equine related matters for me. So I'm lucky in that regard. What I do want to point out, for those of you that are unfamiliar or unacquainted with the equine industry, it is not uncommon for contracts and agreements to not be in writing. One of the first things I ask a potential new client when I'm contacted regarding a dispute, did you have a contract? And you would be surprised how often the answer is no, that they don't. And so we're going to go over some of the common contracts that are used in the equine industry and certain considerations to include in those agreements. So here's a list of the common contracts that we use. Boarding agreements, liability waivers and releases are very, very important. Purchase and sale agreements and lease agreements. And all of these are ripe areas for legal disputes. Okay, so a boarding agreement, this is where somebody's keeping their horse at a stable and usually paying someone to not only for the stall, but also for the care and maintenance of the horse. So in a boarding contract, very, very important to be specific. In the equine industry, there are terms of art. such as full board and part board. And you don't want to rely on those terms of art simply because what one person considers full board may not be what another person considers full board. And despite the fact that these terms are commonly used, we don't want to rely on them in the contract. We want to spell out what exactly it is, what services the stable will be providing, what they will not be providing, and what is expected of the horse owner. Another key provision to include in a boarding agreement is payment terms. Especially when I'm representing a stable, I will always recommend that they get board paid in advance, simply because it's a lot easier to get the payment ahead of time or know you're going to get paid, obviously, than trying to get it in arrears. I should also note, keeping horses is pretty expensive business. Most of these boarding stables aren't doing this really to make money. They don't make a lot of money, generally speaking, running a boarding stable. And as we have more and more development, particularly down here in South Florida, there's fewer and fewer stables that have a facility to offer all the people that want to own a horse. And so these people, it's imperative that they get paid up front. They don't want to get thousands of dollars into the care of a horse and then the horse owner skips town or leaves the horse, abandons the horse. In our neck of the woods, and I'm not sure about Georgia, but we also have what are called seasonal barn rentals. And again, this is because of the fact that we do have the Winter Equestrian Festival going on here. A lot of these participants will rent an entire barn. The barn owner does not provide any care at all. They simply rent them the facility. And so those agreements require obviously different terms. And I do work with a lot of the realtors in this area. These barns get put on the multiple listing service through the real estate agents. However, in Florida at least, there are no standard barn lease agreements that the realtors can use. Therefore, and I've had them try to modify a residential lease agreement to a barn rental, and it just doesn't work, and it can have disastrous consequences, in fact. Another important provision to have in the boarding agreement is a termination provision. At least in Florida, I don't know about Georgia, and I suspect Georgia's the same. There are no statutes such as we have in landlord-tenant law that have termination requirements, notice requirements. What this means, and a common scenario, Joe horse owner's keeping his horse at a stable and he likes the facility and he's been paying board, faithfully on time. And suddenly the stable owner comes to him one day and says, I don't want to board horses anymore. You're going to have to move. And perhaps Joe horse owner doesn't have anywhere to go. I get those calls all the time. They want to know what their rights are. And like I said, usually there's no contract. Even when there is, I find a lot of times these contracts that people have copied off of the internet do not even have a termination provision. And in that situation, Joe horse owner is going to be out of luck. He's going to have to remove his horse. He doesn't have any rights under law. Another important provision are Stableman and Agister's liens, which I will talk about more in depth later in the presentation, but it's important. Now, these liens arise by state law, and every state has these state liens, including Georgia, but I always include them to put everybody on notice that, hey, there is this ability for the stable to impose a lien on your horse if you don't pay the board. And the final thing that's very important to include are liability release. And again, these are by state law, and every state, we'll talk about this again in detail later in the presentation, but every state with the exception of 2 does have a Equine Activity Liability Act. Okay, so I mentioned earlier full board and part board. Generally speaking, when you hear a client discuss these terms, full board is where the stable is providing everything for the horse, the stall, all the feed, hay and bedding, and the care. Sometimes they will include extras such as giving the horse supplements, blanketing, trailering, but not always. And that's why it's important that the contracts spell out what exactly they will and won't be providing. Part board, just like it says, it's a hybrid of the full board. And this is, again, it can vary considerably with what's included in part board, but generally speaking, the stable is providing a stall and usually feeding the horse for the owner once a day, typically in the morning, but not always. Generally, the horse owner is responsible for cleaning the horse's stall every day and taking care of the horse. and providing all of their own feed, hay, and bedding. But again, this can vary considerably. A dry stall, this is simply where a person rents, like I spoke about earlier, the barn. They just simply rent the stall by itself, or they rent an entire barn or facility. And the owner of that facility does not provide any services or equipment or supplies whatsoever. The horse owner is completely on their own. It's important if you're drafting agreement such as this, especially for the facility owner, you want to make it very clear that the owner is not only required to provide all of the hay and feed and bedding, but they are required to do so in accordance with your state statutes. You don't want somebody that's renting your facility and not feeding their animals, or, you know, even worse, having animal control show up because there's a problem with the way the horses are being kept. And another type of situation is what we call turnout. These are generally used for horses that are maybe injured or retired, and nobody's providing care every day. They may, but typically they're kept outside in a field or a large pasture, generally with other horses. And some places will have stalls where they'll bring the horses in if there's going to be bad weather, but not always. Sometimes the horses are just simply turned out with no supervision at all. And again, it's important that the owner of the horse be aware what the owner of the facility will and will not be providing. So these are the concerns of the stable owner versus the horse owner. As you can see, there's some overlap, but there are also some more unique concerns in each column. Stable owner's primary concern is obviously getting paid. As I mentioned earlier, maintaining a horse is very expensive and getting more expensive every day, I might add. They're also concerned with eliminating and reducing their liability. Horses are big animals. They can be dangerous. They can certainly injure and cause death to people and damage and destruction to property. And another concern that the stable owner has is termination. Horse owners alike are concerned with termination, obvious for the scenario that I discussed earlier, where the horse owner has nowhere to go or is told on short notice to remove the horse. Horse owner also needs to know what services the stable is going to provide. They're also concerned with safety and security. I always recommend to the horse owner, you know, have boots on the ground. Go out and inspect that stable before you move your horse to it. I can't tell you how many times I've had disputes where the horse owner, you know, wants to sue the stable owner because the facility's in poor condition or the horses aren't being cared for. And if they had simply visited the stable ahead of time, that would have been very revealing for the horse owner. And the other big concern that the horse owner has is obviously a lien attaching to the horse pursuant to that state law that we mentioned earlier. And ways you can mitigate stable owners' risk, as I said, have them pay in advance for the month, require a notice of termination. That way the stable owner, if the horse owner decides to just up and move and take the horse from the facility, that the stable can at least get 30 days so that they can re-rent that stall. They don't want to have stalls sitting empty because that's money that they're not getting, obviously. Most of my contracts do state that board is not refundable once it's paid, and that ties into the termination provision so that the stable owner can have that stall filled as much as possible. Insurance is a very important component. I always advise stable owners to carry general liability insurance, as well as care, custody, and control coverage. Even if the care is minimal or they don't anticipate providing care, these policies are generally very inexpensive, but they provide a great deal of protection, and they're absolutely worth having if there's any possibility that they're going to be caring for those horses at all. I would also mention horses nowadays can be very, very expensive. I have dealt with situations involving horses that were purchased for hundreds of thousands of dollars and actually millions of dollars. When you're talking about the upper level Olympic caliber show jumping horses, they can run in the millions of dollars. But even your, I hate to say run of the mill, but even a run of the mill horse can cost tens of thousands of dollars. So the liability is certainly a large component. The lien that the stable owner can impose on the horse and the personal property is a very strong tool in their toolbox to get payment from an owner. I will mention that holding a horse for non-payment of board has its own set of risks, and that needs to be weighed carefully before going ahead with imposing a lien. and exercising that lien. The ways a horse owner can mitigate their risk, again, have that contract as specific as possible. I've had horse owners say, well, my horse has to get a special feed, he needs to have certain medication, but the contract didn't have any language in it whatsoever. And they're left with trying to argue that that's what the stable was supposed to provide. And as attorneys, we know how that's going to turn out. Inspect the premises before they enter into any board agreement. The horse owner alike should also have insurance, not only on their horse, but also on their equipment. Saddles nowadays can cost well into the thousands of dollars. Bridles can be very expensive. They also would, most horse owners are going to want a provision for termination so that the stable owner can't kick them out with 1 day notice. And advise your client the effect of the state lien laws in the event that they don't pay the board. These are some other provisions that I include in all of my boarding agreements. Access. You'd be surprised how many times horse owners want to visit their horse in the wee hours of the morning, 2 o'clock in the morning. I've had it happen, and it upsets the stable owner, particularly when the stable owner lives on the premises and they've got cars driving to the barn at all hours of the night. Believe me, it does happen. So important to put those stable hours in the contract. An emergency contact person. There's nothing worse than the stable owner trying to scramble to find who the horse owner's veterinarian is in the event that the horse is colicking or cast in its stall and they need to get somebody quickly. Best to have all of that information right up front. Also include a provision in there that if the stable does contact a veterinarian and maybe it's not the horse owner's regular vet, make it very clear that that horse owner is responsible for any of the charges that are incurred for securing that emergency help. Extras, like I mentioned earlier, I would attach a copy of a price sheet if the stable has one for all of the a la carte items. Health and vaccination status. Every contract should include this. Under at least Florida law, all stables are required to have a proof of what's called a negative Coggins test on every single horse that's in that facility. And they will send inspectors around and check that the stable operator has this proof. Coggins test is for a disease called equine infectious anemia. I believe all states have that requirement. It's required for interstate transport. But it is also required for boarding stables. It's a contagious disease. That's why it's so important. But it's important to note that just like the human HIPAA laws, that a veterinarian needs to have the owner's consent to release those horses' medical records. So if a stable goes to the veterinarian and asks for a copy of Mrs. Smith's horse's Coggins tests, that veterinarian by law cannot release those records without the owner's permission. So just go ahead and include that in the contract. It avoids a fight later on if you need to have that information so you can comply with your state's laws. Okay, we're going to talk about liens. As I said, and I'm going to provide a map resource later on that's going to be very useful. It's for all of the states and all of their agricultural liens, not just stable Agister's liens. But as you can see, most states, I think actually all states have these liens. The requirements vary, but generally most states allow for what's called a non-judicial sale, which means if a horse owner doesn't pay that board bill, if it's only 30 days late, that stable owner can turn around and have that horse sold at a public sale without going through the judicial process to recoup the money that they're owed for board. It's a very alarming provision, and I oftentimes get calls from the horse owner who's freaking out because the stable is threatening to sell their horse for the board bill. And they are allowed by law to do that, and they can prevent the horse owner from removing the horse from the stable pending the sale. In these situations, it's a very emotional situation, and very often the police are called to intervene. Most of the liens, they allow for unpaid charges for feeding and carrying animals of another. Now, the liens can be very broad. As you'll notice, the liens arise from the care and maintenance of others' animals. For example, I've had stables trying to impose a lien because, for example, a boarder didn't pay the stable for transporting the horse to and from a horse show. That doesn't necessarily fall under care and maintenance. I would draft a provision in the boarding agreement that provides for those extras that the stable might be providing to also be subject to a lien if it's not paid. But it's important to be aware of what the statutes do cover, and it's generally for only the care and maintenance of the horse. Training, that's arguable if that would be considered care and maintenance. What I'd like to do in Florida, we have a statute for liens for improving the property of another. I've used that where the charges included not only the care and maintenance of the animal, but also training. And the training can be very expensive. In our area, it's about $1,000 to $2,000 a month if they're also providing training services for that horse. So if your client is a stable and they're providing training of that animal, you want to make sure that you include a provision in that boarding agreement that the lien will also cover that type of service and not just the care and maintenance. One more note, where you've got a situation where the person who's keeping the horse at the stable is leasing that horse, find out who the owner is. If somebody's leasing the horse and perhaps they're disgruntled with the horse and they feel like they got a bad deal, the horse owner may have no idea that there is an unpaid board situation happening. And that would also provide leverage to get paid, because certainly the owner's not going to want to lose their horse because the person leasing it isn't paying the board. So get all of that information up front, find out who the actual owner of the horse is. I mentioned earlier the risks of holding a horse for unpaid board. The pros, obviously, it's going to get the horse owner to pay if they have that ability. They don't usually require court action. Montana is one state that does require court action, but most states do not. As I mentioned also, these liens arise very quickly after only 30 to 45 days in arrears, and most states do allow for a non-judicial foreclosure of that lien. The risks, find out what that horse is worth. If the horse is only worth $1,000 and they owe you $5,000 and you're going to continue feeding and maintaining this horse, it may not be worth it. You might be better off advising your client, who's the stable owner, to hold the tack and build that into your boarding agreement, that part of the boarding agreement allows them to store their items of equipment and tack at the facility and allow that to be encompassed by the lien. And you don't have to feed a saddle every day. So it's much more worthwhile to, and easier probably, to sell a saddle than a horse. I also mentioned I've had many instances where the police were called. As I stated, it gets very hostile. I've had physical altercations over the stable refusing to release a horse, and it can get very ugly very quickly. All right, we're going to talk about Equine Activity Liability Acts. We refer to them as EALAs. I mentioned earlier, these are the only two states in our country that don't have an Equine Activity Liability Act as of right now, and that's California and Maryland. Every other state has a version of an Equine Activity Liability Act. So who is protected under these EALAs? They generally protect, quote, an equine activity sponsor and an equine professional from liability that's due to the inherent risks of equine activities. And these state acts came about because of the importance of preserving the equine activities that people love to enjoy, renting out a horse to go on a trail ride. Out west, you have dude ranches where people like to go and camp, or they go on trail rides. Without the protection, it would make these activities cost prohibitive. The risk could ruin a facility that offers these types of activities. There are some exceptions in some states. Generally, it's negligence and obviously wanton willful misconduct. Some common examples of negligence that can, where the stable would not be protected under this act, if the stable provides faulty equipment. For example, a rotten girth and the saddle slips off the horse because the girth was rotten. There's a dangerous latent condition on the facility. Another common one is mismatched horse and rider. You put an inexperienced rider on a high-strung, maybe young, untrained horse. It's a recipe for disaster. Those are all exceptions to the Equine Activity Liability Act. Another thing you need to look at, what is considered an equine? What types of activities qualify as an equine activity? Not all activities, although most will qualify as an equine activity. Who qualifies as a participant? Who qualifies as a sponsor or an equine professional? And what steps does that sponsor or professional have to take in order to enjoy the protections of their state's EALA? Under most of these statutes, an equine is defined as any horse, pony, mule, or donkey. Now I've included Florida's definition there from statute 77301. Interesting side note, these pictures, the top picture is a horse and a donkey. The picture on the right is a pony, which is it's an adult animal, but they are vertically challenged. That's their mature height. And the picture on the bottom, the creature with the white creature with the long ears, that's what's called a mule. And I don't know if you know this or not, but a little piece of trivia. A mule is the product of a horse and a donkey. And all mules, male and female, are sterile. They can't reproduce. So if you want a mule, you have to breed a horse and a donkey to get one. So just an interesting piece of trivia. Some of the state EALAs will apply very broadly to farm animals or domestic animals, not just horses. So this would cover, for example, places that have like a petting zoo or maybe an animal rescue, a dairy farm. So it's very, very broad. Kentucky has the language farm animal. It encompasses horses, ponies, mules, donkeys, ostriches. Who would have thought of an ostrich? Which, by the way, can deliver a pretty mean kick. Kansas, they use the term domestic animal. And as you can see, it's very, very broad. What is an equine activity? Well, this is important because whether it's an equine activity or not is going to depend on the definition. And of course, will dictate whether the activity provider has protection under state law. But generally, it's going to be any type of equine activity. Horse shows obviously fall under that. Training and teaching, those are considered an equine activity under Florida's law. Boarding, so if you got your boarding stable, they're going to be considered having an equine activity on their premises. Riding, inspecting, or evaluating a horse. So if you have somebody that's just coming to the barn to watch their friend ride the horse, that person could be considered participating in an equine activity. In Florida, a person who provides veterinary treatment, that's considered an equine activity, as is a farrier who's putting the shoes on the horse. That's also an equine activity. Under Kentucky's statute, a farm animal activity is also very broad. As you can see, it's similar to Florida's. It includes treatment rendered by a veterinarian and shoes put on the horse by a farrier. Who is a participant? Under Florida's law, any person that's engaging in an equine or any equine, I find that language interesting. It includes the equine that participates in an equine activity, whether or not they've paid to participate in that equine activity. I believe under New York's law, New York requires that the participant had to pay a fee for the activity for the EALA to kick in. Kentucky, again, very broad, any person that's participating in a farm animal activity, as that term is defined in the statute. An equine activity or sponsor or professional under Florida's law, again, very broad. Pony clubs, hunt clubs, therapeutic riding programs. We have a lot of those in our area. They provide therapeutic riding to handicapped individuals, people that have experienced trauma. Very, very helpful, but it's important that these organizations are aware of this law. It's very important protection. Professionals, that would be your person who's a trainer or a stable operator. It could also be the veterinarian or the farrier. Anybody that rents equipment to a participant can be considered an equine activity sponsor that's subject to the statute. As mentioned earlier, you need to advise your client what steps they need to take in order to enjoy the protections of their state's Equine Activity Liability Act. All the states require posting of signs. Now in Florida, they can either post a sign or have a contract that contains And I copy the language from the statute verbatim. Florida does have that definition, that language verbatim in its statute, and all of these signs are copied right from the statute. So I always recommend to my clients that they do both. There's no reason not to. If you're going to have them go to the trouble of signing a contract, by all means, include the state's equine activity liability. And I put it right above the signature line where they're going to sign. And you want these signs posted on the facility. I recommend posting them at the entrance to the facility where they drive in. I also recommend posting them at every entrance to the barn, as well as inside the barn. And I also recommend that they post them on the right at the entrance to the riding arena. That way nobody can claim that they didn't see the sign. Okay, so I was just talking about this. Check your state statute. Florida's, and I believe all of them have requirements on not only the language, but also very, very specific instructions on the contrast of the letters. Florida requires a 1-inch minimum height of the letters. And they also allow this to be in a document, but best practice is to just do both. Have those signs, have that language in your contracts. I had a situation one time involving a farm that allowed the general public to come onto the farm once a month. It was kind of like a petting zoo situation, but they had horses and goats and chickens and all the farm animals. And it was a wonderful activity. It was a wonderful event. It was very much enjoyed by the general public in the area. And they had a person that filed suit against them who claimed that one of their horses had, quote, viciously attacked him while he was on the premises. Now, this particular facility required every vehicle. It was one driveway in and out. They required every vehicle that was coming in for that event. All the occupants of the vehicle had to sign a liability waiver that included Florida's EALA language in that waiver. And this person sued them, and it was a questionable suit, to say the least, but they could not find the contract that this person had signed. Well, using Facebook and other social media, we were able to determine that this person commonly used a different name than the name that was on the lawsuit. And we quickly found in contract that they had signed the waiver that contained this language. And as soon as we produced it, the other side dismissed the lawsuit. It wasn't going to go anywhere. It was dead in its tracks. A horse biting someone is considered an inherent risk of an equine activity. Generally, any action by the horse that, bucking, taking off with the rider, that sort of thing is going to be considered an inherent risk. Here's some Florida cases involving Florida's Equine Activity Liability Act. The first one, Delalo, by and through Delalo versus Riding Safely. This was a stable that offered hourly, you could rent the horse for an hour, go on a trail ride. This case, the accident that happened, it was a 14-year-old girl. She was riding the horse. The horse took off with her during the ride and ran her into a tree, and a tree limb impaled one of her legs. It was a horrific injury. Interestingly, the cases they went to the 4th DCA in 1997, but the injury took place just before Florida passed its Florida Equine Activity Liability Act. It was not in place when this accident occurred. At the trial level, summary judgment was entered for the stable operator under the Equine Activity Liability Act, but it was reversed by the appellate court because they would not apply the statute retroactively. So this just shows you the power and the protection that these acts provide the riding stables. If that act had been in place when this accident took place, that riding stable would have been off the hook. Walt Disney World, summary judgment in their favor based on its release and indemnity agreement that the plaintiff had signed. And that one included a release of even negligence, which Florida does allow. And then, of course, McNichol versus South Florida Trotting Center. The court that determined what an inherent risk of an equine activity is. The question in this case was whether a mound of dirt that was piled up in the infield that prevented the driver from diverting the horse into these infield when the horse took off constituted an inherent risk of equine activities. And the appellate court reversed the trial court and held that that mound of dirt was not considered an inherent risk of an equine activity. Here's some cases from around the country. One of these is Georgia, Holcomb versus Long. That one upheld summary judgment for the stable operator, and it did allow them to be shielded from liability under Georgia's Equine Activity Liability Act. So as you can see, these acts are very powerful protection for stable operators. Liability waivers, these are also important because not only do they provide proof that the person's aware of the state's ELA language, but you can broaden the protection. For example, if your state allows it, you can waive negligence. Now, not all states allow that. You also want to make sure that they have these liability waivers in all their contracts and have them signed before the activity takes place. I know that seems common sense, but again, you'd be surprised how many times people will come to you and say that they had this contract, but they tried to get the person to sign it after something had happened. Well, naturally, they're not going to sign it and waive their rights after something's already happened. So do it beforehand. There's 2 states that do not allow waivers of negligence, Montana and Louisiana. You cannot waive negligence at all in those 2 states. Other states do limit the type of negligence that can be waived. New York, I mentioned that earlier. They can only waive negligence where the participant had paid a fee to use the facility. Okay, equine purchase and sale agreements. This is another area that I get a lot of calls on. Somebody's purchased a horse, they're disgruntled, they feel that the seller withheld information or duped them. Number one, it's important to check your UCC statute of frauds in Florida. Written contract, if it's for a sale of goods over $500, has to be in writing. Big issue that I've run into numerous times, always confirm who the actual owner of the horse is. You would be surprised how many times the person that's claiming to be selling the horse doesn't own the horse. It's a trainer, it's an agent. So it's very important. And that ties into fraud. I've had situations where the agent sold the horse to somebody and the actual owner received a small fraction of the purchase price that the buyer paid, with the agent taking the lion's share of the money. That is a very ripe area for litigation, at least in my neck of the woods. You can check, ask the seller if there's a doubt as to who the owner is, ask them to show a bill of sale, look at the registration papers. Now, I will caution you, not everybody registers the horse in their name. A lot of people will buy the horse, they don't bother sending the papers in to, for example, the American Quarter Horse Association. That's a breed registry. If they don't send the papers in, the horse is going to still be in the name of the prior owner. Doesn't mean that that person doesn't own it, but again, the bill of sale is the best way to determine who the owner is. USEF. USEF is the acronym for the United States Equestrian Federation. It's the governing body for most equine competitions in the United States, especially hunter jumper, those types of events. Their own bylaws state they are not an ownership registry, but I always use it because it can simply give you good information and it gives you a starting point. I would certainly question if I pull up the USEF records and it has somebody else's name as the owner, you could at least inquire, why is this name different from the name that's going on this bill of sale? And then again, social media, I always find is a very good tool to ferret out who the true owner of the horse is. In Florida, we have very specific requirements regarding the sale of horses. Florida Administrative Code specifies the minimum information that must go into a bill of sale. I can tell you, most of the time, a lot of the times, I've had clients buy horses $300,000-$400,000, and there was not even a bill of sale. They simply wire the money, and I know it sounds outrageous, but you would be shocked how many times this happens. When there is a bill of sale, I would say 8 times out of 10, even the minimum information is not in that document. I'm not going to go over and read through all this, but you can see the information that's required. And in Florida, the failure to provide a bill of sale or to include this information in the bill of sale is considered a Deceptive and Unfair Trade Practice Act, which can open up the seller to liability under that statute, which also includes attorney's fees. So it's very important to check with your state's requirements if they have some, and be sure that that bill of sale has at least the minimum requirements. Other provisions that need to be included in any standard purchase and sale agreement. I always include a form selection clause. I'm usually dealing with a seller and a buyer who are in different states. Obviously, if you're whoever you're working for, you're going to want a forum most favorable to your client. You also want to have attorney's fees in that agreement. When risk of loss transfers under the UCC, it can vary. So you want your agreement to state when that risk of loss. Certainly, if you're the seller, you want it to transfer as soon as possible. Another key provision, warranties and representations. I will say this, horse people are very savvy. The ones that do have a written bill of sale, they've learned one thing. They've learned to put that as is language. I have yet to see one that doesn't include as is provisions. They've learned one thing, and that is you better have that as is provision. And it is powerful for the seller. It really, it prevents that buyer from coming back and claiming that that horse wasn't fit for the purpose. Now, when I'm advising a buyer, they'll come to me and tell me, I'm buying this pony for my daughter to show in the children's pony events. The seller says this pony is perfect for that. It's, been showing in that division. It's perfect. And then they show me the document that the seller is asking them to sign, and it's got a disclaimer of all warranties, fitness for a particular purpose, and as is. And my question to the buyer is, well, if your seller is representing that this pony is perfect for your 10-year-old daughter and safe, why on earth aren't they putting that in the bill of sale? And I cannot tell you how many times I've had disputes over language, and they tell me, oh no, but they told me that it was perfect for this, but your contract doesn't say that. And that gives the seller an immediate escape clause. So take that out. And if that buyer gives pushback, doesn't want that provision in there, I would ask the buyer to question them, why not? If you're telling me that this pony is perfect for my daughter, put it in the contract. Another provision that we see a lot of the times, trial periods. Now, these can get very, very tricky. The person buying the horse or pony wants to try it out, make sure that it is appropriate. There's a lot of pitfalls for both sides. Obviously, the seller is going to be concerned. What if something happens while the horse is on trial? Who's responsible? And this is another huge area that's ripe for legal disputes. So try to spell out all the details in advance so everybody knows what they're getting into. Also, require that seller disclose the horse's veterinary records. As you recall, there's no requirement that they have to produce all the vet records. Now, Florida's law requires that if a horse had certain treatments, for example, shockwave therapy, within the last 2 weeks, that does have to be disclosed. But otherwise, without the seller's release of the horse's veterinary records, you're not going to get those vet records. And especially once something has gone south and there's a dispute, you're even less likely, and you're going to have to wait until you're in litigation and discovery ensues to get those records. It's always best to get them up front. And again, if the seller refuses, that would raise concern for me why they don't want to disclose the horse's medical records. The other thing that's important, have the disclosure of all the agents involved. It gets very, very gray when you've got a lot of people involved, and there's a ton of fraud involving agents and non-disclosed agents and who actually owns the horse. It's a very problematic area. So be sure the contract states who all the agents are and what they're getting paid. Horse lease agreements. I have to say, in the last year, I've had more disputes and litigation in the last year over lease agreements gone bad than any other area. I don't know what it is lately. I guess a lot of people are leasing horses, but I've listed some of the common disputes that we see. The person that owns a horse restricts the person leasing it from using it for the purpose that the person wanted to lease it. I have a case pending right now where the person leased the horse to be able to show it in the 3-foot jumpers. And yet the contract says that the horse can't be jumped over 2 foot. That's a little bit of a problem. Now the person's not getting the bargain that they paid for. The lessee's dissatisfaction of the horse. This is often tied into claims of fraud. Well, the horse was perfect when I tried him at your farm. He went around beautifully. I get him home, and a week later, he's taking off with me and refusing jumps. And there's usually claims that the seller or the owner is, concealed information about the horse's, true abilities. Another situation that commonly arises, person's disgruntled with the lease, they don't like the horse, they want their money back. And again, this is another provision that horse people, when they do have a written contract, they always seem to include, there's a no refund clause in that contract. So here you have somebody that's paid tens of thousands of dollars to lease this horse. And 2 weeks into it, they've got a horse that is not only unsuitable, but possibly even dangerous. And now they're out the entire lease amount. And now they've got to pay for the feed and care of this horse for an entire year. It's a very unfortunate situation. And I always wish that I could have been involved in these transactions before the documents were signed. But unfortunately, the reason people are coming to us is usually after a problem's already arisen. The other problem I mentioned earlier, the person leasing the horse is boarding it and they don't pay the board bill. And now the stable owner, who has a legal right to assert a lien on it, is potentially going to take that horse and sell it out from under the owner, and they're not even aware of the problem. And then purchase options, that's another area of dispute. Again, we can eliminate a lot of these, be very careful drafting of the lease agreement. A lot of these people will call you up and say, oh, just send me one of your standard lease agreements, and they want to use that for their transaction, yet it doesn't include any of the provisions that they need. And of course, I get these documents that they copied off the internet, and they're woefully deficient. So these are some key provisions to include what the horse can and cannot be used for. This protects both the lessor and the lessee. Disclosure of vet records, just like with a purchase agreement, it's important that they disclose those veterinary records ahead of time. Also, and even with a purchase of the horse, always, 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 always get a veterinary exam. Now, I'm not saying this because I'm married to an equine veterinarian, although I can tell you from experience that oftentimes a veterinary exam would have eliminated the problem very early on and saved the person a lot of heartache down the road. Get that vet exam. That establishes a baseline that the lessor can't come back and say, well, you caused that injury to that horse. I've got another lawsuit involving that. And the person leasing the horse certainly would never have leased the horse had they known that this horse had an injury that prevented it from being used for what they wanted to use it for. Also spell out who's going to be responsible in the event the horse is injured. That's very important because the lessee could be stuck with a horse that they are now having to feed and care for quite some time. And all the while they're paying for all the bills. Termination and refunds. Your lessors are not going to want to refund money, but that could be a very important provision for the lessee. So something that has to be negotiated ahead of time. Also, disclosure of agents. Again, I can't tell you how many times the person leasing the horse does not own the horse. And there's a lot of funny business, suffice it to say, in this industry. So be sure you know who owns it and who's an agent. And of course, our venue clauses are very important. Most of the time, they are in different cities and states. And just briefly, I'm going to talk about insurance coverage. I mentioned it earlier, stable owners, they want to have general liability, care, custody, and control. The types of coverage that a horse owner can obtain, equine liability coverage. This is going to cover liability. For example, the horse gets loose and runs down the road, gets hit by a car, and kills or injures the occupants of the car. Just like a owner of an automobile, the owner of that horse is liable for the injuries and the damage that horse causes. An equine liability policy will protect them in that event. Equine mortality and medical services. Equine mortality, obviously, it covers the horse owner if the horse dies. Medical services is like our major med insurance policies. You do have to have a mortality policy in place in order to get medical services coverage, but you don't have to have medical services coverage if you have mortality. These are important because if your client's boarding at the stable and let's say, God forbid, there's a barn fire, the stable, if they have a good agreement, they're going to, have the stable horse owner waive liability for the loss of their horse. You're going to want that horse owner to look to their policy for coverage in that event. And again, they can get insurance for their personal property, saddles, bridles, girths, all of that type of equipment can run in the tens of thousands of dollars, very expensive. So it's important to have insurance on that. This is a site that I mentioned earlier. It's the National Agricultural Law Center. And this is a great resource, not just for equine statutes, but all kinds of anything related to agriculture. You can click on the map, click any particular state, and then there's a drop-down menu on the right-hand side, and it'll give you all of the compilation of statutes for that state under the category. So this is a great, great resource. And another good resource for animal law in general, Michigan State University's College of Law, they have a great website. And again, they cover all the different states' laws related to animal law. And thank you so much for having me speak to your section. And I will take questions now if we have any.
There are a few. The first one is, most of them relate to sales, by the way. That's obviously piqued everyone's interest. Can the stable agreement include a waiver of the non-judicial foreclosure sale?
I don't know of any cases out there, but I would say probably not. That's a good question. I'd have to look into that. That's a very good question. I think my knee-jerk reaction is that they probably can't waive that, but I'm going to double check.
Okay. The next one is, can the horse owner pay the board bill in full before the sale of the horse and then remove the horse? In other words, if the horse was going to sale, can you come in? I interpret this question as like last minute and say, hey, here's the board bill in full, stop selling my horse.
Yes, they can. And actually, and I've had this in a case where the stable was trying to sell the horse. They threatened to have a non-judicial sale. Under Florida law, the horse owner can post a bond. And once they've posted that bond, by law, the stable must release the horse. And if they don't do it, it's actually a criminal violation. So wow. It's a very powerful tool. We did use it in one case where they refused to release the horses, and my client posted bond and the stable had to release the horse. They had no choice. So they could either post a bond or, like you said, they can simply pay the board bill and get that horse released. There's not a lot of cases out there, and I suspect that's because most people aren't going to lose their horse over a board bill. They're going to lose if it comes down to that. The horse owner is going to lose.
Wow. So you may have actually answered this question. I'll ask it in a little bit different way. Are there any circumstances aside from posting the bond or paying in full, or aside from posting the bond, are there any circumstances in which the boarder can refuse payment from the owner before the sale and say, I'm going to sell the horse instead? In other words, if he was owed $30,000 and is a $100,000 horse, are there any grounds under which, aside from this bond, they could just say, I don't want your $30,000, I'm selling this $100,000 horse?
Well, if I had a situation like that, I would encourage the horse owner to post a bond and trigger the stable's liability under that statute, where if they fail to release the horse, it's a criminal violation. It's got some teeth to that statute. So no, I don't think that the stable has a choice at that point, but to release the horse. They must release the horse.
That makes sense. And I guess that emphasizes the fact that in every state, you should look and see what those statutes are in case this becomes an issue.
Absolutely.
There's another question came in and said, I'm impressed with your licensure in so many different states. Do you feel it is necessary to be licensed in more than one state in order to have a profitable equine law practice? And if so, do you feel that the fees you can earn from a multi-state practice justify all of the expenses involved with state bar dues and CLE and insurance and that kind of things, travel?
Well, I think that, I don't know, to answer your question, no, I don't think you need to be licensed in multiple states. I happen to be licensed in multiple states because I spend a great deal of my time out in the western part of the country, in Montana, Wyoming, and Colorado. So for me, it made sense. But I will tell you, the majority of my equine law cases, 80 to 90% of them are here in Florida. So I think it just depends on where you are. If you're in states like Florida, Kentucky, California, Texas, Georgia has actually got quite a bit of equine activity. Then I don't think you necessarily need to be licensed in multiple states. And certainly it's something to consider. It is a lot of CLE and dues and all that. So you just have to weigh whether it's worth your while. I've always wished I was licensed in Kentucky, because more often than not, I'm looking for somebody in Kentucky to help out as co-counsel, or a lot of these disputes somehow seem to end up in Kentucky. But it just depends on your circumstances and where you are, and how much need you see for that in your area.
Interesting. I'll ask one more question as a equine enthusiast and not an equine attorney. What are the guidelines for these sales? How do these sales occur? Does somebody just go to the courthouse steps like they do with property on a certain date? How do these horse sales occur?
Yeah, so in Florida, you're required to post. There's really, these statutes are actually quite old and antiquated, and they've actually been criticized for being somewhat out of date. But in Florida, you only have to post the notice in 3 conspicuous places, 2 of which, one is the courthouse, and the other one is at the stables, place of business. The third one could be a tack store, a showgrounds. They don't specify. And that's really it. There's no requirement. I had somebody ask me the other day, are you required to have an auctioneer? No. In fact, they don't have an auctioneer. And these sales tend to be very poorly attended, because most people don't know what's posted at the courthouse. And if they happen to walk into their tax store, they're probably not looking to see what notices are posted. So the sales that I'm aware of that have occurred have had the stable owner and the horse owner in attendance. And we know who's going to win. It's going to be the stable owner, and they get possession of the horse. There's a case in Florida, I believe it was in the Ocala area, where a stable sold some valuable thoroughbred racehorses for the board bill. And the owner didn't even know the sale was happening. And it was upheld, went up on appeal, and the appellate court upheld it. They went, according to the statute, and the owner lost all of his thoroughbreds because he didn't pay the board bill.
Wow.
Without any notice.
That's scary stuff. And that certainly underscores the need to have everything in writing, especially if you're leasing a horse to someone else who's paying board, things of that nature. Well, I don't see any other questions. This has been incredibly informative. I know I have learned a ton today. Got a lot of pointers, a lot of things to think about, a lot of things to consider and put into practice with future equine negotiations and transactions. And I can't thank you enough for being here and speaking to us. You've been so kind with your time and to come and present to us. This is our first CLE of 2022, and I just can't thank you enough for being here.
Well, it was my pleasure, and I thank you for having me and allowing me to speak to your section. And you have my phone number, my email there. If anybody has any other questions or wants to reach out, certainly feel free to reach out to me. I'm happy to help. And like I said, I'm always happy to talk about horses. So.
Fantastic. Well, thank you again. Thanks to everyone who attended today. I really appreciate you attending. Again, next CLE event should be April the 6th, another noon event. So look for an invite for that shortly. And fingers crossed, we're hoping for the in-person outdoor wonderful venue social event the last week of April. So stay tuned for more details for that. You can always go to our website. It's georgiaequinelaw.org. And with that, thank you again, Lisa and Lane. I think we're a wrap.
This
Thank
concludes
you.
today's webinar. Thank you for joining and have a great day.